Good morning, everyone. Thank you for joining us today, and welcome to the third and last session of our lecture series, Rule of Law and Democracy, which is part of the series within Postdoctoral Dialogue Series, Norms, Plurality, and Critique, organized by Carlos Galvez Bermudez, Sophie Moller, and myself, Maria Emilia Barreiro. We all at Normative Orders. So today we will have a talk by Professor Cristina Lafont, who is professor at the Department of Philosophy of the Northwestern University. She's the author of Democracy Without Shortcuts of Oxford University Press, 2020, Global Governance and Human Rights, Spinoza's Lecture Series, Van Gorkum, 2012. The Linguistic Turn in Hermeneutic Philosophy, MIT Press, 1999. Heidegger Language and World Disclosure, Cambridge University Press, 2000, and co-editor of Critical Theory in Critical Times, Transforming Global Political and Economic Order, Columbia University Press, 2017, and the Habermas Handbook, Columbia University Press, 2017 as well. She was published numerous articles in contemporary moral and political philosophy, and her current research focuses on normative questions in political philosophy concerning democratic and citizen participation, global governance, human rights, religion, and politics. She's the director of the program in critical theory and co-director of the research group on global capitalism and law, funded by a Big Ideas grant of the Buffett Institute at Northwestern University. The topic of her talk today is Rule of Law and Democracy. So please go ahead, Professor Lafont.
Thank you so much. Thanks so much for the invitation to participate in this lecture series. I'm delighted to be here and especially looking forward to our discussion after my talk. So what I'm going to present today is a defense of the democratic legitimacy of judicial review that I have in more extensive form presented already or articulated in my book, my new book, Democracy Without Shortcuts. But in that book, that argument is part of a broader argument in which I defend what I call a participatory interpretation of deliberative democracy. Because of the topic of this lecture series, the rule of law and democracy, what I'm adding to the argument that I present there, although here it's going to be very compressed because I only have 30 minutes, is to try to explain what is it about the rule of law, the fact that judicial institutions and judicial review too contribute to uphold the rule of law. What is it about the fact that they are judicial institutions and uphold the rule of law that is also, according to my argument, contributed to the democratic aspect of judicial review that I defend. That is something I have not answered in the chapter of the book. But let me first mention that I'm focusing on a strong judicial review, but this is not because I want to argue that a strong judicial review or even judicial review is necessary for democracy. And the reason I don't argue that is not that I have particular suspicions about it, it's because I don't think that there is a normative answer to the question of what kind of like one-size-fits-all set of institutions are kind of democratic and will need to be like having by all kinds of countries. I think that this is really a largely empirical question. What type of institutions you have in different democratic societies, it very much depends on traditions, on path dependency, on many issues. And so I don't have a view about whether any democracy or any new democracy, for example, has to have it or not. So what I'm arguing is more against the view that a democratic society that has even strong judicial review is less democratic or less democratically legitimate for that reason alone. So that's kind of what I'm trying to say. That's not the case either. Okay, the difference is that the kind of argument that I'm presenting is not the one that you usually find in the debates, especially among legal scholars. And so we'll see what you guys think. So critics of judicial review of legislation argue that given an unelected institution the authority to strike down legislation that has been enacted by a democratic legislature is inconsistent with the democratic ideal of self-government because it takes away the power of the citizens or the people or their elected representatives to resolve questions about their fundamental rights. And by contrast, defenders of judicial review often argue that the only way to secure the conditions within which all citizens can participate as equals in democratic self-government is to limit the power of the majority to enact legislation that violates fundamental rights of minorities. I agree with the need to secure equal rights protections, but I disagree with the reasons that are often used to justify judicial review as the best institutional way of doing so. So I want to defend it as a good way, but not for the reasons that are often presented. In particular, I would like to question a key assumption that both defenders and critics share, namely the idea that judicial review of legislation involves letting judges interpret the meaning of our rights for us, instead of letting this task be performed by the citizens themselves through public political deliberation. In my view, if that's correct, then the case is made against judicial review. If that were the case, then it could not be a democratic institution. So I'm going to try to show why I think that that's not the best analysis one can make of what is it that judicial review as an institution does. So in order to do so, the reason why I think that this is just taken for granted is because typically judicial review is analyzed through a narrow jury-centric perspective. Looking at the institution not in the context of the set of institutions within which it makes sense, and from a diachronic perspective, looking at how the process plays out, the political process within which judicial review works, right? By looking exclusively from a jury-centric perspective to how the courts work, what are the beliefs of the judges, how do they rule in the end, and only looking at the end of the process, so to say, the perspective of the contribution or what is it that citizens have to do with that institution simply is out of the picture. You don't see why is it that we citizens are supposed to make use of that institution. How can we endorse that institution? It seems to have nothing to do with us. So what I do is to adopt what I call a participatory perspective. So from my perspective, the question is, what does this institution do for citizens? If it does something that can be defended democratically, then it's a prima facie case in favor of the institution. If it does nothing that somehow contributes to the ability of citizens to participate in democratic self-government, then it doesn't. And I think just adopting the perspective at least will help in moving this debate forward, in my view. And so from this perspective, I argue that the main contribution of judicial review consists in securing citizens' right to effectively contest the political decisions to which they are subject. So if citizens have a right to legal contestation, then you need an institution that enforces those rights, that makes it possible for citizens to legally contest decisions that they think violates their rights. And if that is their fundamental function, or at least the one that most contribute to a form of democratic control, then it seems to me to be prima facie democratic. However, even authors like Pettit, who famously defend legal contestation as a form of democratic control, still conceptualize this contestation that citizens are doing through those processes as an apolitical affair, as a depoliticized venue that removes the issue from political debate among citizens. And so legal contestation is portrayed as an apolitical mechanism that individuals have at their disposal in order to counteract the tyranny of the majority. And this is, in their view, precisely what justifies judicial review over legislative supremacy, according to this view. So unsurprisingly, this picture of judicial review immediately raises the anti-democratic objection. For example, Waldron characterizes citizens' use of legal contestation as an attempt to obtain an unfair advantage over other citizens who limit their participation to the normal political process. The idea is that citizens are political equals to the extent that they have an equal right to vote, and that those who look to judicial review after having been outvoted in the political process, are simply trying to get, this is a quote from Waldron, greater weight for their opinions than electoral politics will give them. They are kind of like doing a kind of double counting, right? Trying to get it both ways. And so therefore, that's another quote, the attitudes towards one's fellow citizens that judicial review conveys are not respectable. They kind of go directly against political equality. However, Waldron's objection seems to be based on a misleading analogy between the right to legal contestation and the right to vote. Whereas the latter gives citizens decision-making authority, the former does not give citizens any such right at all. The right to legal contestation does not give citizens any right whatsoever to decide the case or to contribute to decide the case. What it gives them is the power to request a fair review of a case on the basis of reasoned arguments. The right to legal contestation is a right to a fair hearing of arguments and objections against a statute that purportedly violates the Constitution. It gives citizens the opportunity to try to convince the court and other citizens of the merit of their case. But precisely because the process is driven by the merits, there is no sense in which the litigants are getting some extra or unfair political influence. By using the legal venue, litigants do not acquire any power to make their views and arguments any more or less convincing than they actually are. The right to legal contestation is more modest. It gives citizens a right to be listened to open or reopen a conversation based on arguments and evidence about the constitutionality of a statute, so that explicit and reasoned justifications for and against the statute in question become available for public deliberation. Granted, the political process also allows for that kind of reasoned deliberation in both the legislature and in the public sphere. However, it cannot really guarantee it. Statutes and policies often do not wear their potential unconstitutionality on their sleeves, so to speak. Consequently, there is no way to guarantee for each piece of legislation that the political process will reliably identify all potential collisions with the fundamental rights of different citizens and groups, such that they can be preemptively subject to proper political deliberation and rule out with convincing arguments. Moreover, since there are bound to be disagreements among citizens regarding whether or not the statute in question violates rights, it is unlikely that those who fail to see any merits in the case will engage in a reasoned revision of their own accord, so to say, since from their perspective, there is nothing in particular to deliberate about or revise. In such cases, the citizenry is very unlikely to engage in a thorough and reasoned debate where all the necessary evidence and arguments are provided so as to convincingly rebut the opinion of the dissenting group of citizens. Surely it cannot be the obligation of citizens or of the legislature to address every single complaint that citizens might have, regardless of how plausible they appear. But this is precisely the kind of obligation that the courts are well suited to discharge. By comparison, what the political process cannot possibly guarantee, the legal process typically does: the individual right to a fair hearing in which reasoned justifications for and against a contested statute become publicly available for political deliberation. The right to legal contestation guarantees that all citizens can, on their own initiative, open or reopen a deliberative process in which reasons in support of the contested statute are made publicly available, such that they can be inspected and challenged with counter-arguments that may eventually lead to a change in public opinion. From this perspective, the right to legal contestation guarantees all citizens that their communicative power, their ability to trigger political deliberation on issues of fundamental rights, won't fall below some unacceptable minimum, regardless of how unpopular or idiosyncratic their beliefs may happen to be in the eyes of their fellow citizens. The political process cannot guarantee that such communicative minimum in the same way that the legal venues can. In light of the enduring presence of political disagreement, it is inevitable that majoritarian decisions on particular statutes or policies will align with the views of some citizens, but not with those of others. Electoral politics will predictably give citizens greater weight for their opinions if their views happen to align with those of the decisional majority or the majority culture. Indeed, the more unpopular the views, the less weight they will have in the electoral process. Thus, when it comes to highly idiosyncratic views, it is perfectly possible that the weight of these opinions falls below some minimal threshold within the electoral process. Even these predictable circumstances, the right to legal contestation, helps ensure the fair value of the right to political equality for all citizens. It provides the power to make oneself heard and to influence public opinion, to have the opposing majority listening to one's counter-arguments and to have them addressed. Moreover, by legally challenging the constitutionality of a contested statute, citizens can structure public debate on the statute in question as a debate about fundamental rights, and therefore a debate in which protecting everyone's rights must take priority over other considerations. They can determine what the main consideration in that debate ought to be. From this perspective, the political significance of the process of judicial review is that it functions as a conversation initiator on the constitutionality of any specific law or policy. And in so doing, it facilitates the constitutionalization of the political debate on the issue in question in the public sphere. This has important implications for the question of political equality. Given the fact of pluralism, citizens are bound to disagree about the right way to frame a political debate. What is at stake, what should have priority. However, other things being equal, democratic societies should err on the side of making sure that fundamental rights are not violated. But how can this be achieved? How can political debate be bent in such a way without giving preferential treatment or superior authority to anyone's views or beliefs in particular? If participants in political debate are supposed to judge the issues on their merits, that is on the basis of their own convictions, there is no particular reason to assume that unfettered political debate will allow citizens with unpopular or idiosyncratic beliefs to structure the debate in a way that goes against what the majority of citizens genuinely find persuasive. If this analysis is correct, then an extra device will be needed in order to err on the side of making sure that those who believe that some fundamental rights are violated have their claims properly scrutinized and appropriately answered, even if most people are convinced that such claims are wrong on their merits. So people can agree to this regardless of what the content of the example will be, for example. In that sense, we can say with Waldron that these citizens are trying to get greater weight for their opinions than electoral politics will give them. However, we need to be more specific about the aspect of their opinions that is getting greater weight by virtue of the right to legal contestation. The greater weight in question is not about getting the outcome that they think is right. If we assume that a democratic system is functioning normally, then there is nothing they can do to force judges to rule in their favor. Rather, the greater weight they are seeking is about receiving the kind of scrutiny that they think is appropriate, and we all agree they deserve as free and equal citizens, regardless of what case we are talking about, even if we think in particular cases that they are plainly wrong about the particular case. Indeed, the claim that the contested statute violates a fundamental right may turn out to be wrong, and litigants may not be able to change public opinion. It happens all the time. But even in such a case, they still have the right to receive a public justification about why the statute does not in fact violate their rights, and is therefore compatible with treating them as free and equal. Moreover, more importantly, for those who continue to disagree, this public justification in turn highlights the reasons, the arguments, and the evidence that they will need to more effectively undermine in order to change public opinion on the matter. It gives them a target rather than a moving target in the public sphere, where you don't know exactly what will it take for you to make your case. Here now you got it, this is what it will take, and maybe you can succeed next time around. Although examples are always problematic, the debate on same-sex marriage in the US offers a good illustration here. It's one that I have kind of lived in real time. For decades, the issue was treated in public debate as turning on the meaning of marriage. On that question, there was widespread agreement that marriage is between a man and a woman. However, once political initiatives for state constitutional amendments to ban same-sex marriage by defining marriage as between a man and a woman became part of the political agenda, and citizens legally contested such initiatives in the courts, the focus of public deliberation switched from an ethical and religious debate on the meaning of the practice of marriage to a constitutional debate on equal treatment and fundamental rights. Judicial review on the constitutionality of state bans on same-sex marriage led public debate to treat the issue as a matter of fundamental rights, because that is the question that was going to be faced by the court. So that was the question everybody had to face in the public debate. Quite surprisingly, once the debate became structured in that way, an astonishing switch in public opinion took place in favor of same-sex marriage. This happened within less than 4 years. Although this development is a complex empirical issue, it is hard to avoid the impression that once the debate became a constitutional debate, many of the citizens who were against same-sex marriage on the basis of their religious or ethical views about the meaning of marriage or homosexuality, etc., could not find convincing reasons to justify unequal treatment under the law, and that they therefore changed their minds about whether it should be legal. In the book that I follow this example, I provide all the empirical information from the Collins, etc., that shows that the change of opinion that moved from being in the majority to be in the minority, those many citizens who changed their views continue to think that homosexuality is a sin and that marriage is whatever it is, etc. And they just change their mind on the legal issue, on the constitutionality issue only. Given the astonishingly short period of time within which that change in public opinion took place, there is no reason to assume that the majority of citizens who initially opposed same-sex marriage were all acting in bad faith or that they were unconcerned about rights and not attending to reasons. Under such an assumption, it would be hard to explain why they changed their mind, why they did not continue doing that. However, there are good reasons to assume that without the extra power that the right to legal contestation granted litigants, such that they could structure the political debate as a constitutional debate about fundamental rights, force their fellow citizens to answer that question rather than the other questions, the unfettered political debate in the public sphere will have continued to turn on religious and ethical questions about which citizens strongly disagree. As a consequence, the religious and ethical views of the majority about the meaning of marriage will have continued to dictate policy. If we focus on the empowerment that the right to legal contestation gives to citizens, we can see the politically significant sense in which the courts can play the institutional role of conversation initiators. It does not mean that the courts begin the conversation on their own initiative, certainly not in a country like the US. I mean, only citizens can bring cases. The court can do nothing. Also not that judges lead the debate because they have superior moral insight or are more sensitive or are themselves more sensitive to principle. In fact, the jury-centric perspective mischaracterizes the actual dynamics of political debate on contested issues. More often than not, conversations surrounding contested political issues have been present within the public sphere long before such issues are legally contested. But conversations that have been structured in a variety of ways become constitutional conversations by, at the latest, the time the contested issues in question are subject to judicial review. More importantly, these constitutional conversations are triggered and are shaped by the creative interpretations that the affected citizens themselves provide of the rights involved in the laws and policies that they are legally contesting. The idea that judges are the ones interpreting our rights completely forgets that those who are bringing the cases are the ones who have to bring the arguments, the evidence, the reinterpretation of the rights. They are doing that job, and the judges may decide yes or no, or may also contribute, but there is obviously something that the litigants are doing and not just the judges. If this account is plausible, then the normative contribution of the institution of judicial review is not, as Petit suggests, that the courts undertake constitutional review in isolation from the political debate in the public sphere, as if justice needs to be in robes in order to properly attend to matters of principle. To the contrary, from a democratic perspective, the main contribution of the institution is that it empowers citizens to call the rest of the citizenry to put on their robes in order to publicly debate rights-related constitutional issues as matters of principle. Now, to the second part then, okay, so imagine that view is minimally plausible. Now the question will be about why does it have to be a judicial institution? What is it about the judicial institution? I'm also suggesting that it's not apolitical, so it seems to go against the rule of law and the independence of the judiciary. So I want to argue that actually it is the independence of the judiciary, the fact that it's not a political institution, that actually does the trick. As we have seen, judicial review offers a key institutional mechanism by which minorities can be empowered to force an otherwise inattentive, misinformed, ignorant, or indifferent majority to listen to their cause and join the political debate on the merits of the issues at hand. Yet the independence of the judiciary is essential for that mechanism to work. For the key presupposition of this institutional practice is that the quality of the legal arguments, the relevant evidence, the reasoning, etc., is what matters for determining the ruling. Indeed, if nothing that the litigants could do can influence the outcome, then what would be the point of bringing cases to the institution? You must think that the institution is really going to judge the case on the merits. That's why it makes sense to try to find the best merits. In contrast to the actions of political parties, which are supposed to be predictable in accordance to their political agenda, the rulings of independent judges are supposed to be unpredictable in that political sense. They are not supposed to be partisan. This is why it's not pointless for citizens to bring cases to the courts to search for better arguments, evidence, precedents, and so on, with the aim of persuading the court and their fellow citizens to change their considered opinions on the issue in question. Thus, the existence of an independent judiciary can empower minorities to be listened to by consolidated majorities, since it can never be ruled out that when citizens in the minority bring legal challenges to the courts, some judge somewhere may actually rule in their favor and against the policies that the majority endorses. In the case of same-sex marriage, I showed that happened. Out of nowhere in 1993, the Supreme Court of Hawaii decided to look at the case for discrimination of the ban of same-sex marriage. And that mobilized the whole country to first, actually a backlash, to go to pass DOMA in Congress, like to absolutely go against it, because that is the problem. How on earth could that judge in Hawaii, out of like after 30 years of attempts, actually rule that way, right? So that can happen. And in fact, that is how it started the whole thing in the US. So it is precisely and only to the extent that an independent judiciary is politically unpredictable, that consolidated majorities must listen to the arguments and the evidence provided by their fellow citizens, since even if their elected representatives are in control of the legislature, even if they have the political parties in their favor, there's no guarantee of a favorable court ruling. It is for that reason that everyone is forced to debate the contested political issue on its merits, on its substantive merits, because that is how it's going to be kind of decided, instead of simply relying on their bigger numbers. This political unpredictability, in turns, helps constitutionalize the debate in question, so that over time, a shared view about rights may come about that brings the contestation to a natural end. However, an obvious concern, if one adopts this perspective, is that national venues of legal contestation of laws and policies that threaten fundamental rights may be exhausted before a shared view on the rights in questions can come about. That happens all the time. The evolution of international law over the past decades illustrates, in my view, the logical response to this important concern. The best institutional way to take away the finality of judicial decisions about rights that are made by institutions with highest national authority is to create transnational human rights courts with the authority to subject such decisions to further scrutiny and to prompt appropriate legislative changes. But the point of creating transnational venues of contestation that can be triggered when national venues have been exhausted is not to establish yet another final authority. Yes, finality has something to do with this process, but I think it just puts us in the wrong track. It's precisely to take away the finality that explains why there are so many instances that are being created, precisely so that there is no finality until the finality is brought by the fact that nobody is contesting the issue at all. Everybody is already convinced. So to the contrary, the point of inducing an institutional dialogue between national and transnational institutions is that it keeps the possibility of ongoing contestation and debate open about the substantive merits of decisions that touch upon rights, so that over time, a settled view on the rights in question may come about. From the diachronic and participatory perspective that I defend, the democratic legitimacy of judicial review is located in the important role that it plays in securing effective participation among all citizens in shaping the meaning and scope of the rights. It's they themselves who are doing it, but that institution, like institutions can possibly do, can help us in the process. By contrast, institutional procedures that circumvent such a needed debate by conferring full legitimacy upon majoritarian decisions, that type of finality, without institutional opportunities for dissenting minorities to challenge them on substantive grounds and not on numbers, are unduly exclusionary and therefore not democratically legitimate. Okay, thank you. That's it.
Thank you very much, Professor Lafont, for this great lecture. And before we go to the general Q&A question, we have 2 comments. The first commentator will be Professor Richard Bellamy, who is Professor of Political Science at the UCL since 2005. He's the author of Republican Europe of State, Cosmopolitanism, Intergovernmentalism, and Democracy in the EU, published in 2019 by Cambridge University Press. From Maastricht to Brexit, Democracy, Constitutionalism, and Citizenship in the EU, also published in 2019, Roman and Littlefield, and he's currently completing a book on democratic constitution for Oxford University Press and development, a study of political leadership, provisionally entitled The Democratic Prince. He's co-editing the Cambridge Companion to Constitutional Theory with Jeff King and the Cambridge Dictionary of Political Thought with Terry Ball. So please, Professor Bellamy, go ahead. You have around 10 minutes for your comment.
Okay, thanks. And I'm sorry I appear twice here, but it's because one of my computers is simply frozen and I can't even turn it off. So I'm on a rather old computer here. So thanks for the invitation. Thanks, Cristina, for your paper. I mean, the presentation you gave just now was slightly different from your written paper, which I had prepared comments, but I'm going to throw them away now because it's like, in your written paper, you didn't specify that you were defending strong judicial review, because one of the things I would respond to, and I will say a little bit about this, is that, you know, in the paper on page 10, you say you're against people who don't believe in any kind of judicial review. But I don't believe that such people exist, or at least they're not amongst the people such as myself in my book, Political Constitutionalism, and Jeremy Waldron, who you criticize. So I think that some of the things that you desire can be found in weaker forms of judicial review. And at least part of the debate is weighing up the democratic qualities of both of those. So, but let me come to 2 elements which seem to me to be points where we clearly disagree. So one is that, is this a normative debate or is it an empirical debate? I think this is one of these areas where it's quite hard to make the distinction between that. I think an awful lot of your argument depends on your view that courts are driven by considerations of the merits of the case based on rights, and that the views that they come to are in some sort independent. Now you have a good case, I mean, a case which didn't apply across all jurisdictions, I should say, namely that the courts have played a role in transforming the same-sex marriage debate. Actually, slightly more legislatures, parliaments, have passed legislation pre-judicial decisions on this than has been prompted by court. So the empirics don't suggest that there's a clear divide between what courts can do and what legislatures would do on this issue. But you know, you've got to consider other cases which are less favorable to your view. For example, you know, Citizens United versus Federal Electoral Campaign, where you have a view on that the right to free speech prevents campaign finance regulation, which seemed to me eminently necessary for the equal voice of citizens in democratic processes, but where rather wealthy funded groups, Citizens United being a right-wing group, have used the judicial forum in order to undermine that. Or think of the whole period of under Mrs. Thatcher, when aggressive judicial review was used to undermine trade union legislation passed under the previous Conservative administration. Lord Diplock characterized that legislation as intrinsically repugnant to anyone who has spent his life in the law or the administration of justice. So a wonderfully independent view from a non-political judge there. But that's been the case, that sometimes these fundamental individual rights-based judgments have been used to overturn what the majority has wanted, because it serves the privileges of a minority. That's the issue. I think underlying this difference is also a difference of the relationship of public rights to autonomy to private rights to autonomy. You quote Habermas's famous thesis that there's a co-originality between these. Now, I guess I take the view, and at times I think this is Habermas's view, and times I don't. I find it a little bit ambiguous in his argumentation. But I take the view sort of that one can find in someone like Bernard Williams, who thinks of himself as articulating at times Habermas's argument, that you don't have private rights to autonomy until you've got a public authority capable of determining them. And what renders then the rule of law progressively more democratic has been the democratizing through the equalizing of power over that public authority. So that means that there is a priority of politics, the public authority, over the private sphere. So one of the worries that I have about judicial review is that it's used consistently as a mechanism for undermining the equity of the public authority, in which the merits to the public of different views have been considered. So in that sense, it does form as a certain kind of double counting. Let me give you two hypothetical cases here, which relate to the times in which we find ourselves. So many people think that the lockdown measures involve an unacceptable and illegitimate constraint on the rights of individuals to go about their business. This view has been very powerfully expressed in the UK by a former Lord Chief Justice, Lord Sumption, who was a member of the Supreme Court. That suggests that it's not a view that wouldn't find its way into a judicial process. I think there have been some Lander Constitutional Court cases in Germany about this, but I can't couldn't lay my hands on them immediately. But now I think in this case, these sorts of cases, you would have an issue where the public dimension has been debated. There has been a debate in most legislatures, as far as I can see, about this very question of what balance should we have between locking down and protecting public health and keeping the economy going. And by and large, politicians have decided that the long-term capacity for people to be able to exercise their private rights requires short-term public health measures which involve a curtailment of some of those rights. It's a difficult decision. It's one that has often involved compromises, which you also don't like. So I should, full disclosure, I've written a book on defending compromise, and which I think, again, it reflects equality, an attempt to give equal weight in a pluralistic environment to the different considerations that people may have, which legislatures do well. So I think in these sorts of cases, the worry is a real one that the court is a bit of venue shopping by privileged groups, businesses, seeking to undermine public measures required to secure the rights of individuals, which legislatures are better suited at dealing with. Now take another case, another hypothetical case, but one which I think is coming in many jurisdictions. Anti-vaxxers complaining, saying that either for, you know, they fit your eccentrics, right? They're not well. Whereas people like Lord Sumption are well represented in most legislatures, perhaps not so many anti-vaxxers are well represented. There are one or two politicians, but they are definitely a minority. Personally, I think rightly so. But I can imagine that, particularly in the United States, there may be a Supreme Court decision which says freedom of the exercise of religion allows anyone, with whatever nutty reason they may have, to not get vaccinated. But as we know, herd immunity requires a pretty high degree of compliance, over 90%. If one doesn't have that, the rights of all of us are put at risk. Isn't that a consideration that you have to be worried about in your account? So those are my objections. I think you idealize how you understand the role of the court and then use that to overcome the argument that Waldron makes about it being an alternative venue, which allows certain views to get double counted, and you minimize the degree to which the majority view may actually be a relevant consideration in a public upholding of a structure where rights do have to be compromised, unfortunately, because there are a number of different considerations in place. Now, it's true, and I grant you this, that courts can't anticipate every single individual case, and that things can be brought to light that they haven't considered. Although I would again modify your view on your optimistic view on courts here, because courts will have to agree that the parties have standing and a case under the law before they consider them. But still, courts deal with individual cases, and that's an advantage in this case. But still, under weak review, you can say, well, that gives the legislation an opportunity to reconsider the case. But ultimately, they make the decision. Moreover, they've already pre-considered compatibility with a legislative Bill of Rights. Isn't that as much safeguard for your kind of concern as you need? Isn't your desire for stronger view going too far, in the sense that, you know, your legitimate consideration, which I accept, could be given in a perspective which still gives supremacy to the legislature? Those are my points.
Thank you, Professor Bellamy. And the second commentator will be Sophie Moller, who is postdoctoral researcher at the Research Center Normative Orders at Frankfurt University. She studied philosophy and semiotics at the University of Copenhagen, the Humboldt University in Berlin, and the University of Bologna. She received her PhD from the European University Institute in Florence, and her book, Kant Tribunal of Reason, Legal Metaphor and Normativity in the Critique of Pure Reason, was published in 2020 by Cambridge University Press. So thank you very much, Sophie. And well, you have also 10 minutes.
Thank you, Emilia. Thank you, Cristina, for this paper. I thought it was a fascinating analysis of the political implications of judicial review. And they really brought attention to the way in which courts open conversations. And I think that's the most powerful part of your analysis, but it brought me to think about what remains judicial about your account of judicial review. And you said a bit more about it now in your talk than in the written paper, but I still have some questions about this. So I have three main questions, and I'll say some more about them in a bit. My first question is, why focus so much on judicial review as considering rights claims and not other aspects of judicial review? The second question is, how can judicial review both serve as a conversation initiator and provide binding adjudication? Because that's also what it's supposed to do. And that brings me to my third question: is Lafont's judicial review still judicial? So on the first question, why focus on judicial review as considering rights claims? So Lafont focuses on the role of claiming constitutional rights through judicial review. And she sees this as part of an institutional arrangement that allows the citizenry as a whole to develop the meaning of their own constitution over time. And she also said this in her talk, that it's a way for citizens to put on the constitutional robes and give meaning to their own constitution. And what she was saying was also that it's a way that citizens interpret the Constitution. But because she focuses so much on the subjective rights, citizens claiming their rights, there are things in judicial review that are left out. So things like review of institutional procedures, in constitutional interpretation plays no role in her view. And I'd like to hear a bit more about, should we leave that out of judicial review? Is it something that we don't really need, or does that need an additional argument? My suspicion is that it's because she's focusing so much on the US-American tradition, which again is what Richard was saying about the mix of normative and empirical analysis. So if you don't specify that you're focusing on this empirical case, then it sounds almost like the whole world should adopt the American model to have a proper deliberative democracy. And then coming from a country like Denmark, as I do, you sort of think, well, is our democracy then deficient because we don't have this tradition? So I think that would be good to have that clarified. Of course, it's also interesting when she's focusing so much on Habermas's account, and you could also have the suspicion that Habermas talks mainly about the German tradition. So there you have a little bit of a clash, I think. So the second point is, how can judicial review both serve as a conversation initiator and provide binding adjudication? So Lafont very much focuses on the idea that courts or individuals bring conversations to courts, and courts then bring this conversation into the public sphere. So it's all about opening the conversation, starting the conversation. She also has this idea that we come to a final view as a citizenry. But the thing is that the courts also need to adjudicate sometimes, as you said, before we reach that final view, right? And Cristina now also specified, well, that's why it's good that we also have the transnational courts, because then you can always appeal a bit further, but they also have to provide binding adjudication. It's not like they can say, let's just leave this question for now. There are too many views here. They actually need to make a decision. and they cannot go back and say, consider the exact same case twice, so they need to provide binding adjudication. So just to cite from the paper, she writes, from a democratic perspective, the main contribution of the institution is that it empowers citizens to call the rest of the citizenry to put on their robes, as she was also said in the talk, in order to publicly debate rights-related constitutional issues as matters of principle. So the whole question is, if this is the point of judicial review, where does the authority to provide a binding adjudication come from? Should we not give up that binding part if it's just there to open a conversation? It sounds like what makes judicial review legitimate is its accidental effect, but how do we then legitimize its proper effect, which is to apply the law and give binding adjudication? So that brings me to the question, would a different type of institution not be better suited for this purpose? Should we not have some other institution? Which is my third question. Is Lafont's judicial review still judicial? Because she focuses so much on its political implications that I start fearing this sounds like she would really like a different institution. So as I said, she sees it as a way of framing the public debate in constitutional terms and set a standard of scrutiny characteristic of judicial review. But she rightly says that we need an additional argument to justify the specific claim that the judiciary is better suited to fulfill this protective function than the legislator. So her argument is it needs to be the judiciary because it opens a conversation about principles. So it's not about compromise, as Richard was also mentioning, it's about principles. But that doesn't necessarily say that it has to be the judiciary. We could find another institution to talk about principles, for example. She doesn't really talk about applying norms. I think that's what's missing. She has three answers to why it needs to be the judiciary. She has first that it's a form of principle. The second point is that the judiciary provides politically unpredictable answers, as she also mentioned in the talk. And the third is that the judiciary is politically independent. I was a little bit surprised by this idea of the unpredictability of the judiciary, because that sounds a little bit scary when we're talking about the rule of law, because, for example, in Lon Fuller's account of the rule of his 8 principles of the rule of law, predictability is one of them. So you get a little bit scared if you have a judiciary that provides unpredictable answers. But as you rightly said now in the talk, the idea is that it's not predictable from a partisan point of view. However, as Richard also mentioned, there are judges who are quite predictable from a partisan point of view, and as people also represent a line of interpretation that is not necessarily all that independent. So what I'm missing is an understanding of what is the kind of deliberative process that takes place at a constitutional court, because all of it is about the kind of deliberative process that takes place outside of a constitutional court, that takes place as an effect of it. But what's actually happening at the constitutional court? So we have a court that has the function of opening, but also closing a debate by providing binding adjudication. We also have the idea that the court needs to apply a law to a case. So where does that leave us with judicial review? Because it seems like we could find an institution that could be a forum of principle and provide politically unpredictable answers and be independent, but does not give us binding adjudication. And would that not fit better with your view of judicial review? Because if it's open-ended, well, we could have an open-ended debate, for example, instead. So why do we need the adjudication is my answer. And finally, because you focus so much on the political aspect of judicial review, you might fear that it upsets the separation of powers, that the judiciary starts playing a political function. If constitutional courts start fleshing out legislation and giving meaning to things that didn't have meaning before, then it might endanger the logic of the separation of powers and start serving a legislative function. So you focus a lot, of course, on Habermas's account in Between Facts and Norms. And there he also has a discussion of judicial review. And he argues that it's legitimate if it's limited to applying constitutional norms that are already presupposed as valid and cannot create new norms. And that's where the distinction between the legislative power and the judiciary power is, because it's the one between discourses that apply norms and discourses that justify them. But the two seem to be mixed in your account of judicial review. So I'm interested in hearing how you're thinking this. Another thing that's different in your account is Habermas has this procedural understanding of the Constitution, and the idea that the Constitution is protecting a procedure. And I think this is also a little bit the German versus the American perspective. Instead, Lafont looks at a constitutional conversation that gives content to abstract rights and allows citizens to take ownership of their constitution. So I think this is a crucial aspect of deliberative democracy, but I'm not so sure that it's judicial review. And something I also was thinking about now in the talk is the question of, it's not just citizens giving interpretations at courts, it's organizations, it's groups of citizens, it's citizens who can afford very expensive lawyers. So it's citizens and other people. And that really brings me back to my question, why does it need to be judiciary, and where do we have the adjudication in all of this?
Can I respond to both of them, or what is the...
So just a second, yes, just before turning over you, Professor Lafont, those who would like to make questions, just write question in the chat and I will put you on the list to make the general Q&A. So please, now, Professor Lafont.
Okay, thank you. Okay, the questions are overwhelming in a way. I cannot answer them all, but I will try to give a kind of gist of my answers, because those have been long-standing debates. It's too much that I will have to cover. But okay, so now to Richard, I have been having a conversation with you for years that you don't know anything about it, which is when I was writing my book. So I feel, and I'm sure you don't feel that way, that your arguments against the way the debate has been shaped are the ones that I also care a lot about, which is, if we care about democracy, it must be because we care about what it does for us citizens, right? It must be because it empowers us. It can't be about some other things. That is the spirit of what I'm trying to argue for. And it's just that you come down into like rejecting the possibility of ever being democratically legitimate or even helpful for a strong judicial review. And I'm not willing to rule it out. But the point of what I want to argue really is not so much, as you have seen, and it's very difficult in this debate to know what people are saying, because everybody is entangled with the aspect that is empirical and normative. So it's a very kind of like entangled debate. What I want to defend is that even, say, imagine is weaker judicial review better. Still, it should be for the reasons I'm defending. We still should not think that it's just because it's less dangerous, but in fact, it does let the judges decide for us. It's like, to me, that's like, no. So why is it easier with a strong? Because obviously you see things more clearly. I'm not saying it has to be a strong judicial review, but even if it were weak judicial review, it should not be for the reasons that typically legal scholars defend, who are really very much thinking that judicial review is all about the judges. I just want to break with that sense that judicial review is about the judges. It's like thinking, I don't know, that hospitals is about the doctors. It's like, no. Or school is about the teachers. It's like, wait a second. No, we have those institutions because of what it does for all of us. We need to have a better view of how do we own those institutions. It can't just be all about the judges. So that is actually what I would like to be able to prompt, at least a little bit of a change of point of view, probably because I'm not a legal scholar. It helps to sometimes to look at things from the outside. It strikes me as much more a citizen than a legal scholar that the debate is too much focused on what judges do. And I think that's not a good way of looking at it. Now, the problem with the cases, right? Citizens United versus whatever, same-sex marriage. I mean, the problem is, as I see it, is the following. The way it came out in the way I develop it in my book. I took Waldron's challenge. He's saying, if you want to make the case kind of consequentialist by looking at how it has actually played out, you are going to be in a messy territory. Some decisions are really bad, some decisions are good. How are you going to decide? It depends on who you care about or what. Do you care more about the LGBT community than about Citizens United or the right to vote? Right. Okay, so the idea is like, don't try on the cases. Okay, well, that makes it hard then. Okay, you cannot use that. He says, no, it has to be a purely ideal this debate normatively. And he says, and once you look at normatively, assuming the institutions could work as they are set up to do, then you got win on procedures because it goes against political equality. Okay, so I took that challenge and said, okay, I cannot use particular cases or trying to see what will work with, like I cannot use empirical considerations because then I am not making the case. Let's talk ideally, let's say perspective. Imagine we are going to set up a democracy in Mars once we get there. We know nothing about who the people who are coming will be, what kind of diversity of opinions will be. We know nothing about that place. Perspective. Can we citizens think, okay, we should have judicial review at all, or even strong judicial review or not? So that's how I took the challenge. And that's why I use the case of same-sex marriage, but it's not to say, hey, it always worked so beautifully. It's to point out what usually is not being pointed out. People think that it's about the ruling of the Supreme Court. I started in 1990 and show how it played out in 30 years. And actually it played out in a very risky way. It produced such a political backlash that if I had been a legitimate community person, I would have been really scared. It looked as if it wasn't going to work. So the point is not really to think, oh, wow, look, this case is perfect, therefore we could not have it the other way. Although I must say, Richard, that the US is not like Europe in so many ways, also for the examples you gave me. I mean, in referendum, citizens were voting for the ban on same-sex marriage, period. Proposition 8 in California, I mean, it was banned in 11 or 13 states by referendum. So the idea that citizens will have come around like in Ireland, don't put your bets on that one. I mean, I saw it playing out literally, right? And it didn't look that way at all. But I don't want to use particular cases. So yes, I mean, once you have an argument that says that in principle, a strong judicial review is not necessarily democratically legitimate, then you want to look at, in particular cases, what to do. For example, I mean, I wrote an op-ed where I was playing all these arguments now about predictability because of what's happening here. They are destroying this particular court by creating a supermajority, a politically predictable court, right? So I wrote the whole op-ed to show why that aspiration is really going to kill the institution. Because then it's like in Hungary, etc. If you don't have an independent judiciary, that institution does not have any power because it becomes superfluous, predictable. People know that. Why would you bring cases? It doesn't provide legitimacy once it is very clear that it's partisan, right? So it will be destroyed because, I mean, frankly, the other sense in which I'm not so afraid of the consequences of giving so much power to a Supreme Court is that, in fact, I frankly don't think it has that much power or it can have that much power. But it's because simply what Aristotle said, like the majority always rules. Like the court does not have the power of the purse or the sword. It cannot enforce its decisions. So even in this country, there is more segregated schools now than in the 50s. So Brown v. Education, Board of Education is no magic. You have to change people's minds. You can't just simply, with the stroke of a pen, make a decision, whether it's the Supreme Court or whoever, or the legislature, right? So from my perspective, it's a whole process among citizens where you can use in your toolkit, you may have some institutions helping you out a little bit, but that's all. Like, it's not magic, it's not more bootstrapping than what citizens are themselves able to do. Like with your examples, I mean, it's wonderful because I'm European, but I'm living in this country, in the US. I mean, wow. What you expect that the political process produces in Europe, a compromise that makes perfect sense about health, here is not a problem because some court may be insane and some judge may think that freedom of religion is, no. The population, I'm sure you have seen it. There is no mandate for masks, that you can't get it done here. This is such a libertarian country that It's not only the court, the political elite, even the population. It's just like, you know, it's not Europe. So if the citizens are where these citizens are, it doesn't matter. It doesn't matter. There is not going to be vaccination mandate because there is no mandate for mask. And this is simply not acceptable for where this population is. And so to me, the courts can do something, but I really think, and it has been shown again and again, they cannot go too far from considered public opinion, from majority opinion. If they do, simply they are not obeyed. They are not considered legitimate. Even in hard cases, there is no secure right to abortion in the South states in this country, period. I mean, this is simply, the Supreme Court does not have the power to enforce decisions. And so I'm not so scared because I don't see that it has that much power. I think it can do some things for us, but that's it. I do think taking away the finality is helpful. So I have another kind of like area of where I work that I do believe that setting up a human rights regime in the whole world is helpful, but there is no magic. So what I will say basically is, I think it's important that we get right what we think of those institutions and why do we accept them, and that we can own them, that we can see what it does for us. And that also tells us how we may change them, even if it's weak. Maybe we could have mini publics also randomly selected, added to the judges doing things like, when we think about changing the institution, it matters for what purpose. So my main point really is not so much whether weak or strong or weak, but whether it is our institution or it's just really literally that we are empowering Martians to decide things for us, because that upholds the rule of law. That's kind of like what I would say. I'm not sure if I answer to everything, but a little bit, you see the gist of what I argue. And yes, probably weaker will be fine, but it better be for the reasons I'm saying. And if it doesn't do that, it wouldn't do anything either. Now to Sophie, okay. Why do I focus on rights? This is really because I'm not trying to have a theory of judicial review, but as it so happens with everything one does, right? You try not to have a complete theory, you try to do something, but then of course you end up entangled with so many claims that if you want to defend them, you end up having to have a full theory. So I'm not saying that possibly that's what it will take. It's just that because that wasn't the project, it's a contingent reason, actually, why do I focus on rights? And I can explain it to you, but you will see it has really nothing internal about the debate on judicial review. In the book, I'm trying to defend the ideal of democracy in an ecumenical way, without having to have a particular view on what the democratic ideal requires. And in order to get away with that, I argue that even people who really only care about their private autonomy, who really try to single-mindedly care their own business, they cannot afford not to care about whether they are being treated as free and equals, and therefore they have to make use of their political autonomy. And that's why no one can afford not to care about democracy. That is the aspect of their constitution they need to own, because otherwise they may not maintain a sense of justice. They may not be able to actually not let themselves be wronged by others or themselves contribute to wronging others. Because of that, we are all on the hook, regardless of whether, for example, we may want to be just apolitical and never do anything. Because I start that way in the book. I try to defend only what, there's a section where I say, what part of the Constitution do we citizens have to own? And I'm saying, at the very least, we have to own the being treated as free and equal and defining what it will take for us to be treated that way. We cannot avoid that. And that is why I just focus on rights. So there isn't anything internal about judicial review. Of course, and I said that many times, but not in this paper, probably, that of course there is also review of executive action, of administration. I mean, yeah, and I focus just only on this. So it's very contingent. Now, you're saying, okay, so I'm saying that it's a conversation initiator, but to the extent that it really has authority for issuing binding adjudication, actually goes against my view. Actually, it doesn't. I absolutely need binding adjudication. Because frankly, it's the only, like, even though it's the accidental, I'm looking at the byproduct, right? So the byproduct of being able to have so much power to turn the whole majority to actually show you the money give you the arguments. Think about that question. If the stakes were not as high as knowing that the court is actually going to bindingly decide, if it was anything less than that, it would have no power whatsoever to actually change the stakes in the debate. It has that power because, in fact, the court is going to rule regardless of what the legislature, their political parties will do, etc. Because of that importance, and only to the extent that this is going to happen, could you have a gigantic majority actually paying attention and really actually having to debate the issue on their merits. You couldn't have it without binding adjudication. I'm not saying that this is the justification for why the court, because I'm not trying to explain what does the court does. I take it for granted that all the explanation about why do we need judicial institutions are fine. Like, let's take anyone, the one you like the most, that one is right. So I'm not trying to explain everything. Why do we need an independent judiciary in so many ways? So all the Fuller principles to me are absolutely necessary. We need generality, we need everything. We need certainty, but political unpredictability doesn't go against legal certainty, right? The opposite of what I call political unpredictability or partisanship is not judging the case on the merits. And that it really is essential. Now, many judges may, in fact, not do that. However, like with all institutions, I mean, if they are humanly run, they are going to be miserable. But having institutions that have to live up to that norm imposes constraints. It's so much harder to be partisan in a court of law than in parliament. I mean, right? So that's the best you can hope for. It imposes that type of norm on those who participate in it. And then you can see, I mean, you are seeing it now in the Supreme Court with this supermajority. They have no possibility right now to be seen as partisan. They just don't. So either they are rejecting the cases or they are ruling unexpectedly because their legitimacy, their power is at stake. If they are now perceived as partisan, they're done, right? So they can't afford that, actually. Everybody was horrified, they will. No, they aren't. Because they can't, right? So long as there is a possibility to transform and pack the court, they are not gonna rule because they can't. So those norms do something. It's true, they don't do magic. I mean, people can afford to do that, especially when not a lot of people are paying attention, etc. So we can find cases of partisan judges, but I mean, we're talking about humans. So what matters is what is the alternative. The alternative would be much worse. So I need binding adjudication. That's why. And in fact, I think like there's a lot of people defending mini publics, like randomly selected citizens, for actually doing part of what judicial review does instead of judges. I have the impression, I mean, I have a lot of problems with that, with mini publics anyway, but I have the impression that if we did something like this, we will be eventually recreating, they'll have to become judges. They'll have to learn. We need precedent, of course. It's true that the rulings of the judges don't look like the debate in the public sphere, but I think it's not necessarily for bad reasons. I think it's because we care about all those things too. We care about certainty, we care about precedent, we care about all the things that judges are taking into consideration, right? So in that sense, it's really not that accidental. I really think that, especially for my argument, binding adjudication is crucial. If not, it wouldn't do anything. They could initiate, I mean, there's freedom of the press and of expression, right? If initiating the conversation were all it took, they wouldn't need that institution. They could do that. I mean, absolutely. They just can talk and say wherever the hell they want. That doesn't do anything, right? Now, saturating rights and whether this is application or justification. Okay. I really think my view is not different from Habermas in the sense that I don't understand necessarily saturating rights as going creatively against the principles of the Constitution. I mean, that could happen or not happen, but in principle, the thing is, even if you have set principles in your Constitution, which is the way Habermas understands the abstract category of rights before they are saturated, the saturation, the giving particular content, cannot be avoided because circumstances changes, say technology changes. So you can't possibly have had a constitution that already told you what to do about surrogate mothers before in vitro fertilization was even a possibility. So yes, the court is applying the constitutional principles to cases that did not exist before. And in so doing, it's saturating our rights, it's clarifying. It's only that I don't think the judges are doing it on their own accord just because one day they wake up and they're like, oh my God, I guess same-sex marriage should be allowed. No, this is done by those who need to come up with the arguments and the evidence and explain exactly which amendment is the one under which they are bringing their arguments. Why is it, right? All of that is being done, and it's done with lawyers, but because lawyers bring the part in which it can be successful based on the Constitution, and the affected parties are bringing the part of what it is at stake. And they are doing that, of course, also in the public sphere, of course, in the movies, in sitcoms, in TV, in books. They are changing people's minds about what homosexuality is and why same-sex marriage is right, etc. Right? And so I don't think I need, like, first, I don't think Habermas has that view that this is pure application when you apply, right? I think that's why he speaks of saturating. And saturating is interpreting. And I think he has a hermeneutic view, like me, of interpretation, where frankly, all interpretation is application. There is no such thing as pure neutral interpretation, right? So I don't see a difference between his view and mine necessarily, because what I add is not that the judges are doing something different. It's that it's not that they themselves doing it alone, or even of their own accord or with their own input. They are doing together with those who are creatively seeing how we need to saturate our rights for new situations, new threats, etc. I don't know whether that is sufficiently satisfactory or you have more questions there, but at least that's the first thing I would say. I think, right, okay, probably that's it. Maybe